Welcome to the Silverstone Technology Cluster's Ask the Expert podcast. I'm your host, Jeannie. The mission of the STC is to support advanced engineering, electronics, and software businesses, and we're always keen to share industry knowledge and insights. In each podcast episode, we sit down with seasoned professionals and industry leaders to uncover valuable knowledge, share real-world experiences, and explore smart strategies for navigating the challenges of modern business in advanced engineering. This episode is brought to you by TC Group, a leading firm of accountants and business advisors with offices in Northampton and Milton Keynes.
Hello, everybody. Welcome back to the Silverstone Technology Ask the Expert podcast. Today, we're joined by Nick Silvester from IP Assets. By the way, I'm Pim van Baas, CEO from the Silverstone Technology Cluster. I'm your stand-in host for today. I've never done anything like this before, so I reckon it'll go brilliantly. Nick, let's turn to you. Could you tell us a little bit about your background? Because it's kind of a situation where it's a poacher turned gamekeeper, kind of, isn't it?
A little bit. And firstly, thanks for the invitation to join on the podcast. My background is in motorsport. This is why I was really interested to get involved with the Silverstone Technology Cluster. It's been really interesting this year. I was a race engineer for many years. I started in Formula 3, taught Checo Perez how to drive a race car. Possibly not quite well enough, but I think he's doing a great job, and he's a lovely guy. And I worked as both a race engineer and race car designer. And the last season I did was 2023. So there's quite a big overlap, but I looked around for something to do sort of 10 years ago that didn't involve living out of a suitcase quite so much. And I arrived at intellectual property law. Being a patent attorney means that you are still right at the forefront of engineering, dealing with interesting new stuff every day. And that really appealed. Turns out that having a background in engineering really helps out with that side of things. And
so you actually understand what people are talking about?
It really helps, yeah.
Yeah.
And I joined IP Asset, as I say, around 10 years ago. And I'm now a partner there, and it's a really great place to work.
Excellent. So obviously you moved into the IP world. And we kind of want to talk about some of the main things with that. Could you talk a little bit about why it's important that people jump onto the IP thing early rather than waiting until the end of the project and then kind of going, oh, we should have thought about that? Because that happens quite a bit, doesn't it?
Yeah. It's never too early to have a chat and understand your position. There's things that can't be undone. A lot of that is around confidentiality. And also, it can inform some conversations you're having with your clients or your suppliers, because you need to be in control of what of the intellectual property you're creating. You know, it's not just your ideas and your inventions. You're also creating intellectual property every time you put together an email with text and sales ledgers and sales contact lists, your website, your marketing materials. These are all bits of intellectual property, and you need to make sure that you're controlling them in your business to trap the value that you're creating for your entity, and make sure that you can exploit it going forwards. Going back to the confidentiality point, if you want to patent or protect officially one of your ideas that's an invention, you can't do that very easily once it's in the public domain. So understanding where you are at early on allows you to make arrangements to keep your options open later on and exploit what you're doing commercially.
Yeah. So right at the start of the project, have that conversation. But presumably that's not just with between you and your client, the people that you're doing the project for, but also presumably between you and any contractors that you might bring in and all of that sort of stuff. It's looking at it from all angles, I'm guessing.
For sure. And in our industry, in the motorsport industry, contractors are used a lot. And they're quite a specific case which can trip up contract companies quite often. The intellectual property is generally owned by the creator, unless it's created by one of your employees, then it'll automatically come into your business. But if you're using a contractor, the contractor will own what they create, even if you're paying them. Unless you have an agreement in place that moves that intellectual property into your business. So if you're using a contract design engineer or you're using a coder for a software project, you really want to have a contractor agreement in place that has an explicit IP transfer clause assigning the IP into your company, so that you have the freedom to exploit that going forwards, and you don't have a difficult conversation later on with your contractor who's coming back to you and saying, excuse me, we've ended our relationship, you can't use that anymore.
It must be quite tricky though, because from a contractor point of view, if they come up with something on your particular project and then they move to somebody else with another project, but they come up with something remarkably similar, if they've given it away, well, if they've assigned the IP rights over to you, then technically that would prevent them from using it there. So that could be quite tricky stuff.
I'm guessing. Certainly a challenge when you're working as a contractor, and that's the flip side. I mean, as a lawyer, you will always represent the best interests of your client. And if I'm working with a company who's using a contractor, I would like to get as much of that IP into the company as possible. If I'm working for a contractor, I would look at it from their point of view. And you want to make sure that you are still free as a contractor to provide your services to another client later on if they come to you with a similar problem, because it's in your head. You're going to provide a similar solution. So it's quite normal for, in particular, if you're working for big companies like Aston Martin, an OEM, or some other a big engineering firm. It's quite normal for their first draft contract to say everything that's created on this project is owned by us. If you're a contractor, having some form of carve out to make sure that you retain your background IP and only IP that is specific to that solution that you're presenting is moved into the client, then you're leaving your options open. And there's a compromise that can be struck that's useful and workable for both parties in most instances.
Yeah. Is it also then in terms of the sort of methodology versus the solution? Like the way that you arrive at a specific solution that you would capture. So is the contractor free to, or potentially free, obviously depending on the agreements and things, but are they potentially free to use the same methodology that they normally employ, as long as the solution is slightly different, or would that include it as well?
Well, it depends entirely. It depends entirely on what's written in the contract. Now, the most blunt contract, the harshest one that might come out of a company would say that anything developed during the engagement is owned by the contract. Now, that as a supplier or as a contractor would mean that if you evolved your methodology, if you evolved your process during that engagement, in theory, they own it. Your new development in your process. You obviously don't want that, and you're going to have to give them. You're not going to make something in the packaging envelope that's specific to that vehicle. It's never going to be something that you want to sell yourself, or, well, you shouldn't do. That's what you're happy to give away. That's what you're supplying. What you need to have is the conceptual ideas of, for example, the suspension geometry, or if you've been employed by one company to make a double wishbone rear end for a vehicle, you're going to be thinking from your head similar to what you've done before, and that'll be why they've come to you, because they quite like what you've done before.
Yeah, of course.
And it's not above clients to say, we really liked what you did on this, can you do it for that? And then tell you that they want to own everything that comes out. So
yes,
there's a sort of bit of hypocrisy on occasion, but contractually reserving that right for yourself as a contractor is quite important.
And I suppose that all of this demonstrates the value of getting in there early. Understand from the outset, what's yours, what's theirs, and whether that's you as a company working with a new client, or whether you as a company working with contractors. Just get all of that stuff out right at the beginning, so everybody knows where they stand.
It helps to define the relationship.
Yeah.
Actually, if you're a contractor, having nothing written down puts you in quite a good position. If you're using contractors, it's very good to have it defined in a contract which way and what falls where. That's important.
Yeah. How do people... I don't know whether this is a dumb question or not. I'm sure you'll tell me. How do people recognize what is IPs or what is worth protecting or what is worth going into? Because I should imagine that a lot of the stuff, it's kind of like, it's just how we do things. Does that make any sense?
Yeah, absolutely.
Good.
And it's something that we come across a lot. We're very lucky. We deal with very clever people all the time by virtue of being part of an engineering creative institution or a scientist. We deal with a lot of creations coming out of universities as well. Very intelligent people tend to undervalue what they create. And to protect something, it has to be new. And it needs to have something it needs to have an inventive step. Be not obvious over what's gone before. Now, obviously, novelty is absolute. That's very easy. If it's not the same as something else, then it's easy for everyone to see that. But intelligent people, engineers, scientists, in particular, software engineers, data scientists, and engineers, tend to think an inventive step has to be huge because once you've created it, it's obvious. If an engineer will tell you everything's impossible until they solve the problem, and then it's obvious because you've come up with it. So obviously it's obvious because otherwise they wouldn't have come up with it. Now, in the legal sense, the hurdle's much lower. If you can't take it from sources that are publicly available, and actually in some jurisdictions it's two sources, if you can't put them together, come up with what you've done, you're actually in the realms of something that's genuinely protectable by way of a patent, which is the most powerful of protections, and recognizing that when you're creating something like that, there are some flags that are very clear, that are easy to identify. If your first solution didn't work, if you had to sit down and work on it for a week or collaborate with your team as a whole to solve the problem because it was really challenging, the likelihood is you've come up with something new and you've made an invention and it's clever.
So is it, presumably you do this sort of stuff. It sounds to me then it's quite worthwhile for companies to get people like yourself involved, to look at what they've done or how they do it or all that sort of stuff, to kind of go like, hey guys, that's a bit there that you really should look at.
Absolutely. It's one of the programs that we run with our clients. We refer to it as a technology roadmap, but right. It's a sit down with the top engineering team and a really deep dive into technology that they've created, problems they've solved, and then looking at each of those and working out what the most appropriate protection is for each of those line items. And we also start that with an education piece to bring all of the engineers on board with the sort of the low level of creation that's required for something to be valuable. Don't dismiss anything. Get it written down, because that in itself is powerful, having a record of what you've created. A lot of very big companies, actually, that create a lot of solutions to problems don't necessarily have a catalogue of what they've created. And that's another side of things that can be very valuable to a company.
Yeah.
But maybe we can touch on background IP in a minute. But yes, getting that information down, working out what is the most valuable of your creations and what's the most appropriate protection. It might be a patent. It might not be. A trade secret can be a great way of protecting something. It's free, lasts forever.
Like the Coca-Cola recipe, right?
Yeah, exactly. And like a lot of the IP that is on every single F1 car, the tank armor that runs across Iran right now at the moment, and in war zones, a lot of that is kept as trade secret because they don't want to share it. The gates on the air intakes for a Concorde was kept as a trade secret.
Oh, interesting.
That was never publicly disclosed because the manufacturers, they use it today on military jets, and they don't want that falling into the public domain.
Yeah, that makes sense. So we will touch upon on background IP at the moment because I'd like to know what that is. But before we do that, so this is quite interesting, and this is something that I've come across in my career quite a bit, where it's kind of similar to the Concorde thing, where it's kind of like, actually, if we do patent that, then it's kind of in the public domain, and people can figure out, our way of thinking, and therefore, we could give away an advantage. And then it's also, it's really expensive. We're never going to sue anybody that copies us anyway. What's the point? Why should we bother?
Why should you bother? Well, okay, if you're a founder and a startup, you're normally putting in place patent protection for your acquirer. It secures market share. It carves out a monopoly that someone will want to invest in. And certainly early on, when you're looking at angels or Series A, some investors don't do too much of a deep dive. They'll go, well, you've been trading a year, you've got 3 patents on file. Yeah, that's about right. Okay, we'll attribute this much to each patent, and it's very, very rudimentary. Later on, during due diligence, which is something we help out on both sides of deals with, there'll be a deeper dive, and they'll look at how useful the intellectual property you've put in place is, the protection. But, and this is the trade-off, if you keep something as a trade secret, it's free, it lasts forever. That sounds great, but it's impossible if you're going to put that information in the public domain. And it's fragile, because if someone chats about it in the pub and you've broken your trade secret, it's done. You can't reset that. You can't put it back in the box. And equally, if you're in a crowded, competitive space and lots of people are chasing the goal that you have addressed, there's no protection against original creation. So if another entity that's competing with you comes up with the same solution, they can bring that to market, and despite you having a trade secret, they can put that out there, they can sell it and compete with you on equal terms.
So in theory, if it is a pub conversation and people let it slip, potentially your competitor who was part of that pub conversation could then patent it, and that means they push you out of the market, or is another simpler stuff?
So you have very limited rights to continue something that you are doing to the extent you're doing it, if you are carrying that out before a competitor patents it, but it's going to make your life difficult. So that's a challenge there.
Right.
Obviously, it has to be patentable, and if you've been chatting about it in a pub, you've put it in the public domain, so theoretically it's not patentable. There'd be some debate there, because by chatting about it in a pub, you've rendered it not novel. So that's...
Oh, okay. So it might not be patentable anyway.
But if you haven't chatted about it in a pub and they've come up with the idea independently and you've successfully held your trade secret and then they patent it and it's not in the public domain, then yes,
they can stop you from doing what you've always done.
It can make your life difficult. As I say, you can continue doing what you've been doing to the extent you've been doing it. So you need to be able to prove what you've been doing. You need to be able to show that.
And the records are super important.
That is one of the reasons that having a record of your background IP is really important, because you can show when you created something, what you've been doing with it.
Yeah.
And conversely, if you do choose to go the route of spending a lot of money and successfully getting patent protection, you are protected against original creation. You have a monopoly in the jurisdictions you've patented to what you have claimed, which can be much broader than your product. So you're carving out a moat around what you're doing to stop others coming into that
and coming up with something remarkably similar but legally distinct.
Yeah, exactly.
Yeah.
And that's what we work with, and all patent attorneys work with their clients, is to carve out the broadest claim that you possibly can to put space around what you're doing and prevent others coming in.
Yeah. But I suppose the way to look at it, because I've come across a lot of people that sort of go down the protection angle, and and you can sue people if they copy you and blah 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 blah. And then a lot of people kind of go like, well, if some foreign mega company like copies me, and they have all the lawyers in the world and we don't, and they have all the money in the world and we don't, we're never going to sue them. But actually, it's much more about company value, building that company value with the suite of patents that you have, so that you become much more investable. So you should see it as an IP asset.
Indeed. Would you believe that's the thinking behind the company name? And yes, it is about building value in the company, but it's not just suing a company. You can pull many other levers. Certainly, if you have a patent that's granted, you can use that to file takedown requests with internet intermediaries. A lot of the bad actors tend to put their wares out through eBay, Amazon, even Alibaba and AliExpress. They have a safe harbor as an internet intermediary only on the basis that they act to prevent infringing activity. And they all have channels where, as a rights holder, you can request that a listing be taken down if it's infringing your intellectual property.
Right.
And a patent will allow you to do that without you going to court, without anything, without the expense of that.
Yeah.
But equally, most patent infringement actions don't go to court. They settle out of court because neither party wants to spend millions.
Sure.
And it needn't be millions, but to enforce something. But it's, in the majority of cases, it moves to a licensing agreement or something like that.
I was just about to mention that where you could go into a licensing thing, because you might want to in your particular sector proceed as you are, but you might be happy to license it out to people that operate in a slightly different sector,
exactly,
even though they utilize the same thing. Could you touch upon the background IP thing to circle back to that?
Okay, yes. Now, background, having a knowledge and a record of your background IP is really important and very powerful. For starters, it's a list of what you've created, and if you're a creative entity, that'll be a list of valuable bits of information. And significantly, if you're then working with others in a joint venture or any other agreement, it's very standard that what intellectual property you have at the date of signing very clearly remains yours, and anything that happens afterwards is up for debate.
Right. So,
and we talked earlier about contractors and needing to retain your ability to keep trading, and the company that you're supplying will want to retain as much of it for them as possible. It's very clear that before the date of signature, background IP will rest and stay with either party. That's normal. So having knowledge, a very clear record of what that is, means that it's in there, in the contract, and you know what it is. It's not up for debate later on when you've supplied a product which has all these features on it, and they say, well, these features belong to us because you did it in this product. And you can say, no, actually, that was background IP. We created it before the date of signature. Therefore, it's ours. And you're in a strong position.
And you could also, in that way, so we were talking about methodology earlier and all that sort of stuff, and that's how you can protect that, which makes a lot of sense. Is there also, mapping out this sort of background IP and creating this list of everything that you've created? Is there then also value to and I don't know who you would talk to, maybe yourselves, but for people to kind of look at that list and kind of go like, hey man, you could license this into jet skis or whatever. So is it actually potentially a good potential source of funding for those companies? Because if you list all the stuff that you've created and there's 5 things in there that actually in your current sector, let's not do anything, but actually you could license it out. I mean, that seems to me that it could be a really, really interesting route for additional funding for a company.
Certainly. And having it in a list allows you to establish that. Now, if you have that background IP in a list, it's probably held as a trade secret. If it's still within your control and not in the public domain. Now, you might choose to patent it because you can patent something for a new use. If it's even known technology, if you're applying it in a new way, can be patentable. So you might choose to patent it. A patent is a very, very good way of constructing a license agreement. You license someone under a patent, they can't use it without your agreement. So that's quite clear. You can license someone under a trade secret, and again, that's got a benefit because it doesn't run out. There are instances even when the trade secret is broken. If a customer of yours has benefited for a sufficient length of time, even after it's no longer a trade secret, they have to continue paying. But it is more fragile and more difficult to license under that method, that protection.
Yeah,
it's one of the strengths of a patent is the ability to license underneath it. It's very clear.
But presumably also then, like even if you've created some things in the past or a while ago, as long as that's still not in the public domain and could still be construed and new and all that sort of stuff, those could be patentable opportunities. Yeah. So actually, it could be quite a useful exercise for any of the companies out there.
Absolutely.
To retrospectively create that list and do all that background IP, not just to create their own company value, but also to potentially license stuff.
For sure. And if it hasn't been created by someone else and put out there, so it is genuinely still new, it's entirely possible. Even if you created it several years ago, as long as it's not been put out there, made publicly available, it's possible to consider protecting it and making that happen.
So people could be sitting on gold mines without being aware of it.
Absolutely.
Worth looking at,
For sure.
I should imagine.
Yeah.
Excellent.
Conduct an IP roadmap.
Yes. Yeah. Okay, so talk to us about an IP roadmap. And that's obviously something that you do, but it essentially, does that involve getting yourself or your colleagues to just have that assessment? And how would that work? What do you do?
We usually, it's quite intense, so we run it over a day, either side of a break for lunch normally, and we sit down with the senior design team and the management, and it can be directed retrospectively to draw out background IP, or it can be forward-looking, or a mixture of the two, to draw out obstacles for bringing something to market, working out what problems have been solved, what the solutions are, and what the appropriate protection is to put in place, or the problems to be solved, opportunities, problems that haven't yet been solved, really making sure that you've got a clear idea of what you've got to accomplish in order to get something to market and make money from it, essentially, and trap the value for your company, prevent competitors from exploiting the same ideas,
and make yourself more interesting to investors. Just in terms of wrapping up, when it comes to IP, what is the one thing you would say to a company? It's kind of like, if you don't do anything else, please do this.
I suppose I'm gonna grab two things.
Right. Okay. Sure. Break the rules. No problem.
Never been one to play by the rules. Yeah, motor racing. It's only cheating if you get caught, right?
Right.
One thing is ownership.
Right.
Dealing with contractors, making sure that your employee agreements are up to date and clear, makes life so much easier later on.
So get in there early and make sure everybody knows where they stand.
Yeah. And the other is confidentiality, making sure that you've got a culture of confidence within your team. It's not just about NDAs with external suppliers. It's about everyone in your company understanding the value that you're creating by keeping the information that's being created confidential, so that they're not chatting about how cool this is down the pub. Because let's face it, engineers love talking and sharing what they've done because it is cool. It's one of the reasons that keeps us going. Love it. But it is a problem when you get a load of us together and we share all of the ideas. That's something that we see quite often, and it can be really dangerous and destructive. So certainly something to bring up fairly regularly with your team. Make sure that they're understanding why and where they're creating value.
I think we have to leave it there, but thank you very much, Nick, for your input. I've really enjoyed this, really informative. Thank you very much.
It was a pleasure. Thanks, Pim. It's been great to chat.
Super.
That's it for this episode of Ask the Expert. Thanks so much for listening, and we hope you picked up some useful insights and inspiration along the way. If you enjoyed the conversation, please give us a like, share or rating on the platform you're using. Please follow Silverstone Technology Cluster on LinkedIn and subscribe to the STC YouTube channel or podcast on Spotify or Apple so you never miss an episode. We'd love to hear from you, so if you have any comments or a particular topic or guest you'd love to hear from, drop us an email to jeannie@silverstonetechnologycluster.com. Bye for now.